Hi, good afternoon. So to take a page from Laverne Cox earlier this morning, we wanted to kind of be aware of where we are in this space and who we're with. So do we have any DE&I practitioners with us here today? Do we have anyone with us today who works on their company's ESG reports, or familiar with that and working in that space? All right, fantastic. So we're calling this a primer, but this can also kind of be our primer, intermediate, moving on discussion. So as many of you know, over the last 15 years, the term ESG has really entered the common vernacular. It started as a discussion about environmental and climate change, and since then, from there, it's moved into a much broader space. What we've seen is it's not just about ESG reports, but we're viewing it in the broader lens of proxies and other statements and what our companies are saying. As we're seeing, shareholders, customers, and employees have become interested in ESG, what our companies are saying, what our companies are doing, and they're starting to demand different information being shared with the public and speaking in that way. And so that's meant intersectionality with the LGBTQ plus community and what it means for our community and what's being said in that space. And so we wanted to talk about that today and talk about the tensions that are created in that regard and what is occurring in that space. We're not here to provide answers. This is really a discussion. We are three attorneys, and as attorneys, we frequently answer things, well, it depends, or give me facts, give me more information. So what we're trying to identify, and we're really just risk identifiers. And so we're trying to identify risks, identify things we're seeing in the market, and things we're seeing across companies. And so with that, let's get to it. So my name is Ryan Terry. I'm a partner at Paul Hastings. I'm on the board of directors Without an Equal. And so one of the things I do as an employment litigator is I work in this space. Over the past couple years, I was engaged in one of the first SEC investigations into ESG communications and what was put out there, and whether that was material misstatements and along those lines. And so I've approached this from an employment litigation perspective, and I'm joined by two other colleagues this afternoon who also have great experience in this area. So if you want to go ahead and introduce yourselves.
Yeah, so my name is Maddie. I'm an associate in the Employment Law Department here at Paul Hastings. I'm based in the Washington, D.C. office. I'm also an employment litigator, so I defend companies when they face employment-related litigation. And I also counsel employers on a wide variety of employment-related policies, some of which play into the ESG concerns that we're going to talk about today.
Hi, everyone. My name is Sarah Besnoff. I'm also an attorney focused in employment law in our Washington, D.C. office. My practice really sits at the intersection of human rights and employment law, which is where ESG really lives and DEI really lives. And we'll break down all of those acronyms today. I focus primarily on pay equity issues, labor rights, child trafficking, and labor issues, and doing a ton of advice work around just ESG and DEI goal setting for companies. I've been with the firm for a long time, but I did get to go in-house for a year with a large tech company, sitting with their human rights team and trying to build out a compliance program based around human rights. So I'm really excited to get to talk a bit about the international perspective on how ESG fits into human rights more globally. And our goal today is just to try to not be the most boring lawyers you meet this time. The purple and pink lights are really helping, but we'll try to also just bring it with some of our own energy. So it's exciting to be here. Thank you all.
We'd like to have more LED lights in our life.
Yes.
Higher production value than we're used to.
Yes. Excellent. So today we have kind of our overview of what we're going to cover. It was really helpful to see who's in the audience, but we also know we have people watching on the live stream. So we're going to do a mix of primer and intermediate level for all the wonderful people who raised their hands, who are in the trenches drafting ESG reports or working on DEI programs. So first, we're going to start with our ESG background and primer, our breakdown of all acronyms. Then we're going to talk about the framework that we see more at the global level with the human rights framework and how it fits into ESG. Then we're going to be employment lawyers for a moment. We're going to talk about employment law considerations of developing ESG and DEI goals and some of the current landscape issues we see in the woke anti-DEI space, which, as well, spoiler alert, is a huge minority of this area of this space, but we will talk about the impact, the outsized impact it feels right now in the current landscape. And then we're also going to just talk about some of the other considerations following the Supreme Court's most recent decision on affirmative action and how it could cascade into the employment context around ESG and DEI goal setting. And then actually, most excitingly, we're excited to talk to you about questions. We'll definitely be asking you what you want to learn more about.
So we're going to talk really fast for the next 54 minutes.
Yes.
All right, Maddie?
Yeah, so I'm going to kick us off with just a level setting. What is ESG? For those of you who work on ESG reports, you already know all of this, but let's break down the acronym. So ESG stands for environmental, social, and governance, and it's really a framework for accountability for corporations and companies. So what do stakeholders want to know about what corporations are doing in these sort of three big areas? The E is sort of the more well-defined part of the acronym because that's where a lot of the regulation started at and focuses on still in the US. So when you think about metrics for environmental concerns, these are really hard data points about environmental sustainability, commitments to deforestation, concrete emissions standards, things like that. So we're a little bit more familiar with that in the US markets at least. The G of ESG is also, I think, more well-defined than the S. So G is for governance. These are things like how is your board of directors run, right? What procedural safeguards do you have in place for your supply chain? What codes of conduct do you have that govern how your business is run? And board diversity can fall under this governance standard as well. So the S is where things are a little more squishy, right? So what are social concerns? What do stakeholders care about when it comes to corporate citizenship as it relates to social goals? So here you have, I think, less well-defined performance indicators, but typically a focus on DEI, which a lot of you are going to be familiar with. It can be a focus on human rights concerns, which can relate to your workforce or your external environment, your suppliers, your customers, the safety of your customers. And then you have things like gender pay gaps, diversity and inclusion programs, which can cover a wide range of concerns, workplace health and safety, child and forced labor that Sarah touched on earlier. So the social kind of wraps all of this in under the S. This is also where you'll find LGBTQ concerns fall under the S of ESG. So when you're thinking about LGBTQ issues in the ESG framework, some metrics might be the Human Rights Campaign's Corporate Equality Index that I'm sure you're all familiar with. You have the Denver Investments Workplace Equality Index. The UN is also developing what they call Sustainable Development Goals, and those include reducing inequality related to LGBTQ plus issues. So that's kind of some of the S of ESG and where the LGBTQ piece fits in. One thing that I wanted to make sure that we emphasize and we'll talk about throughout the program is that ESG goes beyond just your annual report, right? It's not just a publication that you make once a year. It includes any public-facing statements, any commitments that you're making in any of these three areas. And we'll talk about what we're seeing companies do in those areas. And then did we want to cover... Oh, yes, this is still me.
Still you. Over there. So Maddie, what are we seeing about investments in the area of ESG? And how are your shareholders and people making those decisions?
Yeah, so I think the answer to this, or the question that can lead to this answer is, how can ESG make companies more accountable when it comes to LGBTQ issues? And what the answer that Ryan just provided for me is, we're seeing that in the investment space, right? Like, power, it comes from money, and so follow the dollars, right? And so I'm going to read you some numbers so that I don't mess any of them up. But what we're seeing in ESG-related investments is a huge increased focus on socially conscious investments. So the Global Sustainable Investment Association estimates that ESG-related assets account for $1 in $3, one in every $3 that's managed globally. ESG funds are set to grow to $50 trillion by 2025. Over $68 trillion in wealth will transfer to millennial investors by 2030. And that's important because of what's important to millennial investors. So 7 out of 10 millennial investors say that they expect their wealth managers to screen all of their investments for ESG concerns and based on ESG criteria. It gets even more pronounced as the generations go on. So for Gen Zers, that is 90% of Gen Zers who believe that companies have a responsibility to address environmental and social issues that we see play out in ESG frameworks. So I think the message there is there's clear power behind ESG-related dollars, and that is one kind of external factor that can influence companies and hold them accountable to these ESG-related goals. And next, I'm going to turn it over to Sarah to talk about some internal factors and internal elements that companies are grappling with in the context of human rights frameworks.
Yeah, thanks, Maddie. So when we think about ESG, when we're advising our clients, we talk a lot about allyship, right? We talk about what does allyship mean actually for a company who wants to say a splashy headline that they are supporting LGBTQ+, that they are supporting human rights, that they are out front and doing these things that we're hearing are in higher and higher demand from millennial, Gen Z investors, and not to leave out other generations, the percentages are just smaller, not zero. And I think we talk about it a lot as allyship, right? These are ways to actually measure if you are doing what you say you are doing, to prove and to provide some quantification to what your allyship actually looks like. And those are the ESG metrics that people are seeking to show that they have actually implemented the words they're saying. And we see that internationally as well in the context of human rights frameworks. So what does it mean for a company to say that they are actually trying to respect human rights? Okay, so I want to talk to you about some of the frameworks that play out internationally in the context of human rights. Obviously, LGBTQ+ rights are human rights, women's rights are human rights, and all of this is encompassed in a framework that is now applied to businesses. So in 2011, there was the passage of the United Nations Guiding Principles on Business and Human Rights, which apply to industry, apply to private companies. It has 3 main pillars. One is a reaffirmation that it is the duty of states to protect human rights, so states, nations, to actually protect human rights. 2, that it is the duty of companies and private industry to respect human rights in their operations, including their entire value chains, which mean all of their suppliers, all of their employees, and also through their customers. And 3, it was that there have to be, this is the final big pillar, that there have to be ways to have access to remedy, meaning if a company or a state has violated human rights or has created an abuse of human rights, there needs to be a way to seek remedy, to seek remuneration, to seek remediation, to seek a stoppage of the human rights abuse. So those were the 3 main pillars. So we're going to zero in on that second one, which is what is the duty of a company to respect human rights. Well, what the UNGPs, which is the shorthand in the space, the United Nations Guiding Principles, the UNGPs say, is you really have a duty to investigate, to remediate, and to monitor. So you have a duty to conduct human rights due diligence, meaning you have a duty to investigate and look into what you are doing and where there are risks in your value chain to create human rights potential abuses or violations of human rights. Then you have a duty, depending on the severity and the linkage of that human rights abuse to your company, to either stop the action, remediate it, potentially, provide remuneration to the people who have experienced such abuse or risk. And then third, you have the duty to monitor it, to continue to monitor, to test efficacy, and potentially even to report publicly on it, to show transparency, and to move forward. So those were passed in 2011, And companies generally, based on those UNGPs, global, Fortune 500, global companies, have been passing human rights policies which promise to comply with at least the spirit, if not the letter, of the UNGPs. The question has been, as these are voluntary principles, so the question becomes, what does this mean? What should we be doing? And the United Nations Office of Human Rights, the High Commissioner of Human Rights, has given some really helpful guidance in the years since 2011 on how it should be applying to particular communities, particular vulnerable groups. And one of them was in 2017. There was a report issued, and you have the 5 main conclusions from that report up here. And this was the report on how industry should be applying the UNGPs specifically to issues related to the LGBTQ plus community. And these were the 5 main takeaways from that report. So the 5 main takeaways were that companies should respect the human rights of their workers, customers, and members of the public. So I pause there to say, again, this is a reinforcement of the idea of value chain, meaning it is not just what you're doing for your employees, it's not just what you're doing with your suppliers, it's all the way through to your customers, right? This entire life cycle of a company. Sometimes they're called end users. That's like the widget word for a customer, the end users, all the way down. The second is to eliminate workplace discrimination against LGBTI employees. I'll take a moment to pause. This was in 2017, so the nomenclature at the time that's used is LGBTI. Third is support LGBTI staff at work. One of the main examples of this given in the report is employee resource groups. 4 is prevent discrimination and related abuses against LGBTI customers, suppliers, distributors, and insist that your business partners do the same. I think that last part is really important, right? Again, it's about the idea that a company does not just have responsibility for its own actions, but for the actions of its business partners and its suppliers. And 5th, to stand up for human rights of LGBTI people in the communities where they do business. This last one we're going to get back to a few times because it's an interesting point. They're specifically talking about the need to do advocacy against domestic law that is seen to be in violation of LGBTI rights. They're talking about potentially investing and doing donations to groups that are promoting causes to which further these rights. And they're talking about public stances, right? They're not just talking about actions, but they're also talking about being willing to use what they call in this space leverage, being able to use your leverage to maybe change unjust laws that are happening in the settings in which you're working. So this is the gold standard, I would say, from the human rights perspective. And the question then is, how does this play out for international companies, particularly global companies working in difficult jurisdictions? How do you apply this framework to difficult situations? And I think we're going to talk about that a little bit. Yeah.
Yeah, I think let's talk about that because hopefully, as we all sit here today, we feel as though our companies are doing pretty well with respect to 1 through 4, right? As Sarah talks about, those are, there's still qualitative statements and qualitative pronouncements, but number 5 is difficult, and we sit here up here, and the world in which we work, we are all management counsel, which means we all work for companies. That's all we do. We don't work for individual plaintiffs in any employment-related context. And so we work with our clients as they struggle through these issues, and you're trying to apply these standards to what they're doing. And so I think we had one example kind of to think about, or at least kind of a thought study to go through with respect to number 5 and thinking about standing up for human rights and jurisdictional and kind of the international implications of that potentially where someone's operating and what their business model is. So Sarah, did you want to touch upon that?
Mm-hmm. Absolutely. I see you guys can see my secure ID login. Let me know in the back if you need me to jump off for a second. Yes, so we wanted to throw out a hypothetical just to kind of explain how a company, this is a hypothetical where a company has released a human rights policy saying that they're going to adhere to the United Nations guiding principles, that they have taken a step to probably support publicly, at least in their ESG report, LGBTQI rights. And then they're faced with this decision because they are a company in, let's say, the hotel business, and they are debating whether or not to offer hotels in a jurisdiction that has domestic law that would allow the hotel provider to discriminate against a gay couple who comes in to try to rent the hotel. Or maybe they're even in a jurisdiction that would technically, maybe it's not enforced, but technically would require them as a hotel provider to refuse access to the hotel for a gay couple. So should that company not work in that location? What if the company has been there for 30 years and this is a new law and they have employees that they do not want to have to fire or they want to respect, or they actually, even though this law is on the books, it has always been a very safe place for gay travelers to come to, and they want to continue to operate hopefully under the auspices of the official law. These are the types of questions we see from our clients where they are debating, should we leave jurisdictions? Should we enter jurisdictions with hostile laws that are obviously in contrast and conflict with our stated human rights policy? Should we allow people, suppliers, to violate technically the letter of our human rights policy if they are doing so in order to be in compliance with local law, right? And these are really difficult questions. And as Ryan already previewed, our answer is it depends as lawyers. But more fundamentally, I think the UN frameworks do provide an interesting starting point to think through this. And the first is that the idea is that the UN frameworks understand that there will be conflicts at times between domestic law and international human rights principles, frequently by countries who are violating their own treaties that they have signed, right? You have many international treaties that would shock you by the countries that have signed them and the domestic laws that they still harbor, including the United States. And when you think about that conflict between maybe an international treaties that was signed and a domestic law, the UNGPs say, generally speaking, we do not want companies wading into being the deciding factor necessarily. That would allow, for example, the opposite situation where a company says, we're choosing to violate, international principles. We're gonna be the decider. We're gonna refuse to sell this gay couple a cake, right? We don't want that on a large scale. But it does lead to this perverse, difficult situation where a company that has committed to a human rights policy is faced with a difficult decision of how to comply with local law and not risk the security of their boots on the ground, their people who are working in that jurisdiction, and actually complying with the human rights principles that they have stated their agreement to. So the main approach is, under the framework, comply only as minimally as possible. Be obstinate, be difficult, define it as limited as you possibly can. Require all required due process. If the request from the government, for example, is supposed to have a comma and it's not there, you do not give them the benefit of the doubt, you demand the comma, right? You push and you require all local law requirements are met before you comply maybe with a law that would be in violation of your international human rights commitments. And then the third step gets to this fifth point, which is use your leverage, consider transparency on this decision that you have complied with but disagree with, publicize it, consider taking a public stance about it, and consider advocating against the law to which you had to comply. And that's what the UN framework would tell you to do. So I set that up to say, then it becomes the question of, so what are companies saying in this space? Knowing that under these frameworks, they have a duty maybe to speak out against laws that they don't agree with, but there's also a lot of risk there. I mentioned boots on the ground. One of the biggest issues in the international space is if you speak out, will you risk the physical safety of employees in your group? Will you risk unjust arrest for not complying, things like that. So that gets us to the bigger question, though, which is, if we zoom back in on the US and DEI, what are companies saying? What are they doing? How far are they willing to go in number 5? And if they're not willing to go all the way to the gold star of number 5 on the screen, which is standing up for human rights in the communities they do business, why not? And I think for that, I'm going to switch back to Ryan.
Yeah, so along those lines, so we'll shift to kind of, as Sarah said, the US and thinking about employment considerations are really kind of human capital considerations, which involve Can we advance to the next slide, please? If it works. Well, the next slide we'll talk about, there we go, employment considerations, and 3 issues we're going to talk about now. So I think Maddie's going to kind of set those up so that we can tee into what companies are saying with respect to LGBTQ plus areas and issues and kind of along those lines with respect to ESG reports, proxy statements along those lines. So Maddie, if you want to take us through these 3 points.
Yeah, absolutely. So first, just to zoom back out, when we were talking about socially conscious investments a minute ago, right, that is one way that ESG frameworks can help hold corporations accountable towards these social goals, these LGBTQ issues that are important to everyone in this room. It will not surprise you to learn, as I'm sure you are all employees of corporations as well, that on the employment side, you have employees also demanding a lot of their employers, right? It's becoming more and more important to the workforce that the companies that they work for protect LGBTQ rights and support their LGBTQ workers. So this, I believe it was this year, the Human Rights Campaign issued a report, and they found that US employees are 4.5 times more likely to want to work at a company if it publicly supports and demonstrates its commitment to protecting LGBTQ rights. 4.5 times more likely to want to work for companies that make these public statements, not just internal statements. Gen Z and millennials are even more, it's 5.5 times more likely. So again, we see this generational push as the workforce gets younger. Right now, millennials are the largest workforce in history, so this is something that employers need to grapple with. But this, when we're talking about employment considerations, we have to come back to this starting principle, which is that there is an inherent tension between ESG goals and then the metrics and how you measure those, especially in this more squishy social space. So these 3 items on the screen kind of contribute to and play into that tension, so I'll talk about each of them briefly. One is that in the US, there is a patchwork of legal protections. This happens in a variety of legal areas, but in employment law, we have federal laws like Title VII of the Civil Rights Act, but then you have state and local laws that may, in some instances, provide more protections for workers. Or a trend that we're seeing more of is the exception swallowing the rule of religious exemptions, which allow companies to not comply with certain anti-discrimination laws. So you have states that can kind of go both ways from the federal standard. The second area is the issue of policies, right? The law, whether it's federal, state, or local law, that's what companies have to do, right? That's the floor that companies have to comply with. But your workplace policies can and often should go well beyond that. So we're seeing employers who are active in this space and who want to make clear to their workforce and to their customers and anyone that they deal with that LGBTQ rights are important to them, establishing strong workplace policies. These can include codes of conduct and employee handbooks that have anti-discrimination statements that make clear what the company's position is when it comes to supporting LGBTQ rights. There's also policies that are popping up that are meeting the moment with what we're seeing in all of these legislative efforts to undermine the LGBTQ community. So you have companies who, for instance, might offer travel benefits for trans employees who need to travel in order to get gender-affirming health care. So those types of policies can kind of go beyond the floor of the legal requirements and the patchwork that we're seeing. Now, this third issue is something that anyone in the DEI space is familiar with, but it contributes to the difficulty of setting and understanding metrics and measurements when it comes to these clear goals, which is the information gap. So when it comes to how you measure your workforce and do you have diverse leaders, for instance? Do you have, is your pay equal across LGBTQ lines? That can be difficult to assess because data is not collected as evenly on LGBTQ demographics as it is on, race and sex and ethnicity and some of these other demographics that are required to be collected under certain, for federal contractors, for example. So the old familiar issues with self-identification that we all might deal with in our ERGs, for example, or finding resources for our LGBTQ employees, those also plague the ESG space and the metric space, and figuring out how we can determine if companies are living up to their goals in this area. So with those kind of tensions between what companies want to do and what companies can do, I wanted to toss it back to Ryan to talk about what are we seeing in this space? What are companies saying? What statements are they making about their commitments and their actions to fulfill those commitments in this space?
Yeah, and as we think about that and we think about what companies are saying and what they're doing, and specifically with respect to our LGBTQ plus community and along those lines, right? I mean, if we back up 3 steps and think about that, we start from a place of course, our companies are speaking, they're speaking in the market, ESG, we have a notion of truthfulness of the statement and materiality of the statements and what are being made. And so there's an expectation that statements being made, of course, have to be truthful. And if there's material issues, there's litigation and legal risk that follows there. And so companies are having to make decisions about what information they have and what can they say and what can they put out there. And as I mentioned, I've been involved in litigation in this space. With the Biden administration in 2021, announced an ESG task force with the SEC to go and identify, investigate, and potentially prosecute issues with respect to misstatements with respect to ESG. And so we've seen that, right? We've seen that in the E space, the environmental. You may have quantifiable goals with respect to carbon emissions and things that's measurable. That's easy. Well, easier. Easier than the S, right? In Sarah's words, the squishy, right? So one of the investigations that occurred and started in 2021 by the SEC was looking to a company that was being sued by different state entities with respect to discrimination claims. And it became a question of, you say you're a good place to work for women. You've said that in your ESG reports. You've said you're a good place to work for women. Well, this governmental entity is suing you for discrimination. So is that true? Is that a material misstatement? And so that's where the legal implications of what is said in ESG reports and proxy statements kind of hits the ground and hits what we do and how that interplays. And so that's important to recognize for our community and kind of what is said and out there. Because our companies may have policies, they may be doing things in this space, but kind of what are they speaking and saying publicly? As we look at that and we look at that with respect to our community, it's not a lot. And there's kind of reasons for that, right? So we look at one public statement we found as we're preparing for this, and kind of the only one, but a goal to increase LGBTQ plus global partnership target of at least 5% by 2026. Important to recognize there that it was a partnership setting that goal, because there's different legal implications with partnerships versus employees and what that means. And as a partner, right, I'm not covered by Title VII in certain employment laws. And so kind of how that can be established. Then setting forth, and recognizing and making statements about the implications and the difficulties, and some of these are our partners here at Out and Equal making these statements in their ESG reports, but kind of the difficulties of self-ID and the things we've been talking about for years with respect to self-ID and what's being communicated. As we think about what companies are saying in their ESG reports, proxy statements with respect to our community, I break it into 2 areas, right? We have a qualitative area of we are a good place to work. We have these policies. We do this, we do that. We are seeing a shift, though, of more quantitative information, right? We saw that shift a couple years ago of shareholder proposals with respect to pay information and expecting gender pay information in ESG reports and asking companies to post that pay information. Now, as we think about pay information, there's a whole different scope of ways that companies can present pay information. When we hear that women, I think the most recent statistic I read earlier today was women on average make 82% of what men make. Well, that's a statistic that's based kind of on a pay gap analysis. And to not go into the total advanced mode of talking about that, that's a different analysis than we as employment attorneys may think about a pay equity analysis. right? A pay equity analysis would be comparing similar jobs versus just kind of doing an analysis of the average pay by a population across. And so looking at HRC's analysis from 2021, which found that trans women, the pay gap was 60% to the rest of the population. That's a significant pay gap, but what we're not seeing is companies don't have the data to be able to do analysis at that level with respect to their LGBTQ plus populations. So if we look at even companies that are speaking as to pay and compensation, I think that's something that interests a lot of shareholders, it interests a lot of employees, it interests a lot of customers. And in California, it became the law this year, kind of requiring public postings with respect to job postings as to what that range of the salary would be for the position or what that range of compensation would be for the position. But if we look at from 2020 for the S&P 500, we had 67% of companies across that S&P 500 talked about employee compensation disclosures. That's a really broad term, kind of just where different ranges of where employee compensation was. But then when we look at actually doing a scientific or more statistically based pay equity analysis and talking about where's the group of compensation amongst our employees, we were down at 16% of the S&P 500 providing that information. So employees are requesting that information, shareholders are requesting that information, investors are requesting that information, but we're not seeing significant reporting in that space. And it's a tension. I started this by talking about the tensions of the difficulties, and it continues to be a tension with respect to the level of information that is there to be able to provide that level of detail and information. I'm aware of a couple companies, right, that have published pay equity analysis that have done with respect to women and non-binary, right? So trying to bring in scope something that's not just a binary male-female pay equity, but trying to take into account the different self-identification that they have across the company. But again, that data is only as good as the self-ID, and the population there have provided that information. And how those analyses are done. And from our perspective then, the legal risk with respect to that number has to be right? That number can't mislead. That number can't be materially false with respect to what it is, and how you look at that and how you calculate that number. So as we think about our community and what is being stated out there, for us, we wanted to raise today just kind of that reality of that tension and that difficulty, because there's also, in particular, as I think about pay equity analysis, that there is a statistical truth that as the population is smaller, you end up with statistical significance, right? And so it becomes a mathematical problem of kind of what is this going to look like? And so I don't know how we get there and whether I tee it up for a conversation and discussion, right? Whether the women and non-binary is the right grouping for our community to at least look at some type of pay equity, or whether we think our companies should be doing more of a pay gap analysis, right? Which is just kind of the average of compensation across employees across all jobs and across all levels of the company, which is what some companies are posting, right? That's what many are sharing as the compensation, or doing the more scientific pay equity analysis. As we sit here as defense counsel, right? We have a view of what we'd prefer your companies to present, because if we ever have to defend in litigation, we know what makes our job easier, but that doesn't mean that's right from the employer perspective or the information exchange perspective. And so I love Out and Equal, and I love this organization, I love this summit, because I think it kind of comes together, the tensions, the difficulties of like what we want, where we want to go, but also the realities of kind of what we have to do as companies and just the legal frameworks that at times we're working within. So I guess that's my soapbox on what companies are saying and are doing. But as we look across and the breakdown of what they're really saying, I mean, We read ESG reports, we look at those things. There's not a lot with respect to our community in there, and even less with respect to quantifiable information. But I think that's also fits exactly within the discussions we had about self-ID and getting that information out there, because with more data, more information, more can be said with a confidence level of what is truthful and what is true.
Mm-hmm. I think that goes to a question that I wanted to pose to Sarah, because I know you've read a lot of these cases. But when these companies are starting to make more statements, like you said, if we have more data, then we can make more accurate statements about our commitment to these goals, metrics, or even qualitative statements. Or companies are shying away from making those statements. Mm-hmm. Why is that? What is the legal risk that these statements can generate, or that is driving the absence of these statements in some cases? And can you talk about some of those cases?
Yeah, so when an employment lawyer gets to look at a draft ESG report, here's what they're looking at. It's a little bit what Ryan already alluded to, which is there's almost like two sides of the same coin. Both are, on the broad scheme of things, maybe minimal, moderate risk, but it's definitely weighing heavily on your legal department right now. So the two sides. One is what I would call greenwashing concerns, and I'll talk about that. And then the other is the concern of this anti-woke litigation, what we'll call the other side. And we'll get to that next. The greenwashing. Greenwashing is a term that originated really with environmental, obviously, pursuits, which is this idea of instead of whitewashing, you're greenwashing. You're claiming we're an environmental forward company, we're doing all these amazing things while you're dumping pollutants into the river. So the concern was that you're putting forward one face and you're greenwashing the actual environmental work you're doing. Because ESG has really combined social and environmental, we're now seeing the risk of the application of this greenwashing idea, saying one thing, doing another, and we can actually advance the slide, I think. And we're seeing that risk play out now for DEI statements or comments like Ryan said, where he had to defend a company who said they were a good place to work for women, and the government said, is that true? And so you see the government regulators and litigants, you can also have private lawsuits about this, saying you were misled as a shareholder or even misled as a consumer. You can have consumer fraud cases claiming that ESG reports are greenwashing, are misstating the actual work that the company is doing to pursue the goals they've outlined. And that doesn't have to just apply to environmental, it can apply to DEI as well. It's an interesting time. We've seen a lot of these cases. We've certainly seen some government investigations. Those are probably the greater risk right now, is that the government wants to read all of your files and get into all of your data to the extent that you want to be a private company. But that's one risk. But we're also seeing litigation risk. Right now, it has not been a successful theory. We've seen a lot of cases get dismissed on these DEI greenwashing theories. Typically because there wasn't maybe standing as a shareholder or there's complexities within corporate law. A lot of these kind of live and die in Delaware. But the fact that you're seeing them more and more is weighing heavily on your litigation department, who's maybe the last cut with your ESG report. So we wanted to kind of share that. And what's the main concern? Their concern is that you are stating something that you could not back up if you were investigated, or you could not back up if you were receiving a litigation hold and request for documents. So one of the clearest examples was there was a lawsuit which did not go anywhere, but it was against a company, and the allegation was that in their ESG report they said, we always consider a diverse slate of candidates. And the claim was that those, yes, they considered diverse candidates, but those were sham interviews. They would have a token spot, and in fact, they had already, 90% of the time selected the person who was going to get the job, and those were just a sham. And that case did not go anywhere, but I think that that's a framework for maybe a case that could have legs, right? If it in fact is true that there is a disconnect between the public statements and the actual actions. So when we talk to people really interested in pushing their companies forward, the main thing we say is, use this as an impetus to tell your company to support these initiatives. That if you can't just have the glossy statement, you need the funding to actually carry forth with them, because It's incredibly important that you're doing as you say. But that is one risk in terms of why we don't necessarily see a lot of companies putting forth explicit goal setting around LGBTQ plus population. It's because they know that they don't necessarily have the data to back up the statement. So then there's a concern about overstating and getting one of these greenwashing claims. Okay, like I said, we don't want to overstate the importance of the next slide. We can go to the next slide. But we did want to also talk about the risk of saying too much from the perspective of the rash of anti-woke, anti-DEI cases that we've been seeing. So.
And before we talk about legal challenges from the other side, right, kind of from the right wing, and what we're seeing in that space, Sarah's comments made me think of something that kind of, I like action items, right? And so if there's an action item walking out of here today, as we were kind of talking with Sarah, probably all of your companies will hate me for saying this, but I think, talking with your ERG, BRG leads and like working with them and being involved in the ESG conversation and kind of taking this information and the recognition of the tensions and the limitations at times of what can be said, but being involved in those conversations of what can be said and what can be stated. Because to Sarah's point of talking about we as employment attorneys or we as attorneys review them at the end, right? They're written by a different group. It's typically not within the same group, right? So it's at times just the practical reality of how it's put together. So making sure that we have the right stakeholders in the room thinking about those things and talking about those things. And I think that's a way to push one's company forward and be approaching it and thinking about it. Mm-hmm. But then what are we seeing from the other side and the anti-wokeness that we hear about lately? So Sarah, Maddie?
Yeah, I can jump in a bit. So, I think we hear, as Sarah was saying, we don't want to overplay the importance of this because I think this is the noisy side, the other side, but the efforts to kind of squash ESG, anti-DEI efforts are, for now at least, more noise than they are actual risk. But you're probably hearing about this a lot in the news, right? You have governors of conservative or red states. You've got certain members of Congress. You've got state legislators who are trying to stop ESG-related investments in some cases, who are actively trying to stop companies from putting forth DEI programming. Here in Florida, there was the Stop Woke Act. I can't remember what the WOKE stood for, but Stop Woke Act of 2022, which was designed to prohibit companies from requiring DEI trainings. There was a similar effort in Kansas related to board licensing and not subjecting certain professionals or requiring them to attend DEI trainings as part of maintaining their license. So we're seeing these kind of anti-woke, anti-ESG, anti-DEI efforts across the board. We're also seeing some more novel approaches, for now they're novel, in litigation. So class actions or suits being brought by investors, for example, who don't want companies to put forward more progressive ESG statements, who think that they are misusing investor funds. So an example that we found recently was a Stephen Miller-led group, like yes, that Stephen Miller from the Trump administration, has been looking for plaintiffs, so is leading a number of lawsuits against companies who have DEI policies that are meant to increase diversity, making commitments to certain marginalized communities. So the theory is sort of reverse racism, that these efforts to increase diversity actually violate the rights of a majority community, right? Non-LGBTQ, men typically. There's been similar efforts to challenge like supplier diversity programs. All of these efforts that we were talking about that play into ESG are being challenged or talked about being challenged on the other side. There was a recent case brought against a large national retailer, and I was reading the complaint and I just thought this would be a good illustration of what the other side is saying. So it alleges that the retailer betrayed the core customer base and its investors by making false and misleading statements concerning ESG and DEI mandates that led it to a disastrous children and family-themed LGBTQ pride campaign. So, like the sky is falling because, retailers are supporting LGBTQ,
Families.
merchandise. But these are the types of things that are happening. They haven't had much success, but they are out there, and they're risks for companies when they are taking these stands on human rights and LGBTQ rights.
Yeah, and unfortunately, we're seeing a huge uptick following the recent Supreme Court decision on affirmative action. For example, we have received a letter from Tom Cotton telling us to stop advising companies as employment lawyers. Like, we shouldn't be even, we're violating rights by, as employment lawyers, telling people they can have DEI programs. We were one of, I think, 70 law firms that received it. We were happy to get it, at least, I mean, if you're gonna.
We made the list.
We made the list, thank goodness. I mean,
Telling some of the top law firms, right, that you can't advise your clients with respect to DE&I initiatives or anything along those lines, right, given the decision there.
Yeah, and we're seeing there's been like 3 lawsuits just in the last month against law firms for having diversity programs for their own first-year associates. So unfortunately, we are seeing a bit of a domino effect from the Supreme Court decision. So I know we have limited time, but I think it's worth talking about that and how we've seen that cavalcade from the affirmative action decision, because all roads lead to intersectionality.
Yeah, so let's talk about that decision and just kind of what it means, right? People heard about the decision in June that came out with respect to striking down the affirmative action programs at UNC and Harvard. Right, as we kind of look at that and what the court did there, it kind of did it for 3 different bases. Or made 3 different points that are important to recognize and realize as we sit here today. The first was it narrowed sharply kind of the type of affirmative action program that could be. It didn't actually overrule prior precedent from 2003 and earlier. That was one of the questions before the court, is would it actually overrule that? And the court didn't expressly overrule it. But the court, in striking down UNC and Harvard's programs, kind of left a non-open window or sliver that no one's figured out what kind of fits through that window or sliver at this point, or could be. And so functionally, right, kind of eliminated that. And one of the key points there was in the 2003 decision from the Supreme Court previously, in upholding affirmative action program, had said this is going to need to have a logical end, right? Be it 25 years or 20 years. And the court in its decision said, we're 20 years out. UNC and Harvard's program doesn't have a logical end, because the court then pivoted to what are the goals being set forth? And the goals, at least as the court frames them and what was being communicated, is kind of the goals were along the lines of diversity is good. And so having diverse views of thoughts and opinions and all of that within the educational environment is good, but the court felt that wasn't specific. That did not withstand, in the legal term, strict scrutiny. It was too amorphous. It didn't actually have direct quantifiable ways to be measured as to what that value proposition is and how that worked. And then the court turned to the quote-unquote broad and imprecise categories of racial categories that were being used there. They're actually the same categories that are being used by the federal government, and so kind of what that will do practically in the future, but looking at with respect to an Asian population that didn't take into account South Asians and different populations, and sub-series with respect to different populations, and kind of the court called out those issues and kind of the broad breadth by which those categories work. And so that decision, just based on how it was premised and the posture of the case, should only deal with higher education and kind of those affirmative action programs. But of course, we immediately saw the questions of how that implicates. You didn't have to go far. You just had to read Justice Gorsuch's concurring opinion, where he was very explicit that this is based on 14th Amendment, but also Section 6 of the Civil Rights Act, right next door to Title 7 of the Civil Rights Act. And so that it should apply in the same way because he uses the same language. And so we saw this coming with the Bostock decision when people were surprised that Gorsuch had written that opinion, but you could see the writing on the wall at that point of kind of what was being set forth and what was being anticipated, how this notion would be used of using any type of categories for decision making. And so immediately after, the Students for Fair Admissions became the question of how does that apply in the employment context. Now, in the employment context, typically, it doesn't actually change the letter of the law.
Right.
The letter of the law previously already did prohibit types of discrimination or what could be reverse discrimination or things along those lines. We couldn't have, for example, quotas previously, nor can we now. But it became a talking point for people to take on and focus on, to Sarah's point, DE&I initiatives and along those lines and focus. We saw immediately thereafter 13 attorney generals from more conservative states writing Fortune 100 CEOs and putting them on notice with respect to their DE&I programs and what they're doing, kind of, we will be watching you. Right? I mean, that's essentially the not veiled threat, just the threat, we will be watching you and we will be coming after you. We then had on the other side, because of course we then had 7 states that had to respond, to the, don't worry, we'll be there to support you and help you, along the same lines. But kind of, what does that do for our companies? So they're kind of facing those legal risks is a real question. And we kind of pivot back to a real tension of respect to kind of how to manage this and how to proceed through. Many clients that we work with are saying, we don't care, right? We're gonna do the same thing that we wanted to do and we're gonna have the same programs. Others, have maybe quieted their verbalization of what they're doing in certain spaces or how they're acting. As we kind of think about it, what is the risk? I mean, there's different risk profile depending on the different programs. And one of the areas that's probably the most at risk is programs that are, to Sarah's point, kind of fellowship programs, leadership programs that are specific to individual populations. And I think that really impacts our community as we think about different LGBTQ leadership programs and along those lines, and the ability to challenge those and come forward and say, well, no, I'm a white, heterosexual, cis male, and I want to be involved in this program also. Why am I not getting this mentoring opportunity? Or along those lines. And so that's the challenge as we kind of work through here. So we came out and we were honest. We said we would have no answers. We said we would just kind of pose issues and kind of frame this as a conversation and risk points. And that's what we've tried to do today, is kind of be your risk barometers, or at least identifiers, because that's all we do for 12 hours a day, is just identify issues. But I know we have a few minutes. We're happy to take questions. We can stay around after and also answer questions. I see at least one question.
I'm sorry, yeah.
Yes, I think we
have a mic runner. Yes, this one was live streamed. Thanks to everyone watching from somewhere wonderful in Disney World, I assume.
Charles Orkbon, he, him pronouns from EY. First of all, thank you so much. I totally respect that disclaimer in the beginning, just questions, it's a discussion, because we are in uncharted territory. At EY, I help clients develop their ESG reports, prepare for assurance for their ESG reports, and I also assure ESG reports. But not all three for the same client, though. Now, I have had an experience where a client was developing their first ESG report, and I'm coming in doing a pre-assessment and finding this is not ready for publication. It's not ready for disclosure. But the client tells me our legal department has approved us to say this. And I have to, show, no, we should not say this. I'm kind of curious, we're both on the audit side and on the legal side, we're both interested in helping our clients avoid misstatement. How do you see your role different from the sustainability auditor, and in what ways is your role the same?
So first, thank you for saying when it's not ready for publication that it's not ready for publication. Yes. I think we've been talking a lot about ESG recently and trying to get out and talk with companies and talk with employers, and so they're thinking about ESG and thinking about it across the entire scope of the company. Because I think it kind of goes back to Sarah's point before, is the difficulty is we're brought in reviewing ESG reports when there's already an employment issue and already employment litigation. They may not be flagging, and that's why I bring up the pay equity issue and all of that. It's when there's a pay equity lawsuit is when then we're reviewing the ESG report as to what's being stated as the pay equity. And so we want to be involved more at the front end, to your point, and kind of making sure that it is the right people who are making that decision. Because it may be legal sitting in a framework that's like SEC compliance legal or a certain group within legal, but may not be across the whole scope of who's thinking about the different legal issues. And so I think it's like the siloed effect sometimes of what legal is and along those lines. And so we're always working with how we can prospectively put out there and affirmatively put out the information you want. We try to be, I joke that I live in an improv land. I'm always yes and, but like, let me make sure I pivot the yes so it's the right, minimizes your risk, yes.
Yeah.
Basically, hire outside counsel.
But yeah, I would just add, your role is incredibly important, and we hope to see clients using people in the role that you have. And we hope to, I think generally what's our role that's different? I mean, we think we play a similar role, except in the context of the framework that we're applying is one of litigation and regulatory risk. But the issue, like Ryan said, is frequently the lawyers in-house reviewing these are brilliant corporate lawyers who are maybe just not looking at it from the context of litigation regulatory risk, which is much more aligned with the work that you're doing. So when in doubt, it's all about more people at the table, having larger groups at companies, have more interdisciplinary groups working together to avoid those kinds of risks. Thanks for sharing that.
Yes, and I know we're over time, so I don't want to mess up the timing and the framing. So we're happy to stay and answer more questions, but I don't want to, so feel free to. That is our panel. That is our session. Thank you.
Thank you all.